Next matter to come before us this morning is Coleman versus Coleman. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve that time, and if you let me know when you get started, I'm keeping the clock this morning to keep you apprised of the passage of time. We've read the briefs and we're ready to proceed when you are.
To please the court, I am James Coleman, appellant in this case, and represented pro se. I beg the court's understanding if my argument is not presented 100% or as logically as it might be from professional counsel. I have read the appellant rules and am prepared to give my argument today. May I ask to reserve 4 minutes for rebuttal at the end of the appellee's argument. I'm aware the briefs from these procedures have been read. This case is about an ambiguous and alleged debt stemming from divorce proceedings that concluded in 2005 in Summit County, Ohio. I'll demonstrate today that there is a significant and a relevant conflict within the judgment entry of divorce that shrouds unquestionable doubt over the very existence of this debt, that this conflict was presented to the trial court, that the trial court could have acted under proper authority to resolve and rectify the conflict, and that the trial court, through an absence of discretion, chose not to acknowledge this conflict at all, but rather arbitrarily imputed this debt to find the appellant in contempt. To establish conflict, please refer to the judgment entry of divorce, date stamped September 27, 2005. Specifically, Article 3, the division of property. This Article 3 represents all the marital property in existence at the time of the divorce and is reaffirmed in Article 8, disclosure. Further, this Article 3 allows for the equitable division of said property in accordance with Ohio Revised Code 3105.171. Please pay close attention to the Section E, pensions. This section exactly and finitely defines the husband's IRA account as well as the wife's IRA account. Each are to retain as and for their own separate property. Next, refer to the Article 3.1 property payment. Here, the husband is to transfer to wife the sum of $15,000 from his IRA account that he was to retain in full as and for his separate property. Also in this Article 3.1, the ambiguous debt of $15,000 appears to be paid by husband to wife at the 2010 graduation of the younger daughter, Jessica. Clearly, the conflict created by Article 3.1 is sufficient evidence to remove this entire Article 3.1 from the judgment entry of divorce.
What was the date, sir, of the judgment entry of divorce?
September 27th, 2005.
So we're 10 years later.
That is correct.
And during that 10-year time period, there was nothing to suggest that the court was treating this in a way that you disagreed with?
I believe I understand your question to say that this is the first time in the last 10 years that I've disagreed with it?
That you have raised the argument that you're raising now that the debt did not exist?
Yes.
Okay.
Mm-hmm. As far as the conflict presentation, this conflict was plainly presented to husband's counsel, by husband counsel rather, to the trial court during the trial proceedings in its reply brief to the wife's motion to show cause. Here, the husband argues that the different treatment of the IRA, and this is quoted from the reply brief, different treatment of the IRA between the two articles is further proof that any obligation created under Article 3.1 is not a division of property that existed, unquote. The trial court had authority to address this conflict. I call on Irwin v. Irwin. Quote, where there is confusion over the interpretation of a particular clause in a separation agreement, the trial court has the power to hear the matter, clarify the confusion, and resolve the dispute.
If I may, Mr. Coleman, at the time that the separation agreement was executed, the time September 27, 2005, it was anticipated, according to 3.1, that money would be paid upon the graduation of your daughter Jessica. How many years after 2005 was it that she actually graduated from high school?
She graduated in 2010.
Okay, so 5 years later, this payment, according to what the document says, the payment would have become due at that time.
That's right.
Is it reasonable for the court to think that because under 3.0 you kept your IRA, right? But that 5 years from then, according to this, you're supposed to pay $15,000. Would it have been reasonable for the trial court to think that the reason you agreed to this was that you'd have your own complete control over that money in your IRA for those 5 years until the payment became due? Because it's a self-directed IRA, I presume?
I maintain control of it, if that's
Right.
the
So
question.
the court, by you keeping possession of the IRA for that 5-year period, you'd have complete control over the investments of it, and whether it be money or not, or that sort of thing. That would be entirely up to you. Would it be reasonable for the court to think that that was why you entered into this agreement?
I'm not really sure that I could speak for the court in that regard, ma'am. I knew what my understanding was of the agreement on that day.
And how, you signed this, so what was your understanding of it at that time?
So my understanding, and there's a bit more relative to the execution of this document. So if you notice the date of the document, date stamp, is the same day as the trial court's trial hearing schedule itself.
But on this same page of this agreement, which there's no page numbers on here that I can see, I mean, at the very bottom of the page, there was an interlineation here, Article 3.2, the Continental Marriott funds. You initialed that interlineation there on that page. So you had to have read that page at that time. There's no dispute on this page, or there's no lining out here that you didn't agree with it at that time. So you must have had some understanding at that time.
Okay. To answer that question specifically, the issue regarding Marriott points was discussed after the document.
Right, but
So,
what I'm saying is it's all on the same page. So
I don't disagree with that at all. I do recall very distinctly that my focus was to close this issue on that day. And the Marriott points was raised as another consideration. And so my focus relative to that was to that handwritten line.
Right, I
So,
get that.
yeah. Okay. Relative to the trial court review of the magistrate decision, the decision to adopt, reject, or modify magistrate's decision lies within the discretion of the trial court, should not be reversed on appeal absence in use of discretion, quote unquote. However, quote, we consider the trial court's action with reference to the nature of the underlying matter, unquote. This is Tabatabai versus Tabatabai 9th District, Medina. And my submission would be that they consider the trial court's action with reference to the underlying matter. In my opinion, the underlying matter was the very existence of this debt in the first place. Rather, if it had been paid or what actions was due relative to that debt. As far as the standard of review, I think that's been established in our briefs. It's under the abuse of discretion policy. And again, I submit to you that the trial court arbitrarily imputed this debt without first addressing the conflict that was presented to it, and that they certainly had the opportunity on 2 different occasions to address the conflict and to make resolution to the conflict as it was presented to them. I would also submit to the court that the authority of this honorable court is to reverse the trial court decision. Quote, of course, the trial court's discretion, though broad, is not unlimited. A reviewing court may modify or reverse a property division if it finds that the trial court abused its discretion in dividing the property as it did. Section 3B, Article 4 of the Ohio Constitution, Appellate Rule 12. This is from Cable, 1982. Also, please consider appellate court, quote, reversed in part because it incorrectly included the party's children's custodial accounts in its division of marital property, unquote. This is from Miller versus Miller, 9th District. I bring this to the court only because it's a clear demonstration that when the property division was found to be in error, that the appellate court has full authority to reverse. Statement of errors, Trial court erred in finding husband in contempt for not paying an alleged debt to wife arising from judgment entry of divorce against the manifest weight of the evidence. Simply stated, and as referenced in the appellate brief, all domestic support obligations, including spousal and child support, were paid in full and is not being disputed by the parties. And this is according to, of course, Ohio Revised Code 3105.18 and 3119. In addition, all existing marital property was equitably divided and is not being disputed by the parties according to Ohio Revised Code 3105.171. The only conclusion to be drawn here is that all support and property division was satisfied and that no other debt could have been assumed or speculated. Second, the alleged debt to which the wife refers in its motion simply does not exist. Yet, through an abuse of discretion, the trial court arbitrarily imputed this debt to the husband. The clear conflict in Article 3.1 relative to the rest of the judgment entry of divorce document can only lead to one conclusion: that the entire Article 3.1 should be removed. Also,
Excuse me for interrupting, but what are we to make of the reference in wife's brief that the debt was acknowledged in the bankruptcy, that she was, that the $15,000 was listed and she was named as a creditor?
I did read that, ma'am, and at that time I was represented by counsel. And even in consideration of my pleadings to my counsel, which is to say that the debt did not exist, he included it arbitrarily in the bankruptcy filing. I relied completely on his professional conduct. I'm not a lawyer, nor do I claim to be one, but I relied solely on his expertise.
And counsel, I'm sorry, Mr. Coleman, you're just now reaching into your 4 minutes of rebuttal. You may proceed or reserve as you wish.
All right. Very briefly, closing statement, if I may. The only reasonable conclusion from the preponderance of the evidence is to remove Article 3.1 from the judgment entry of divorce, reverse the findings of the trial court, find in favor of the appellant, and consider this case closed.
May it please the court, your honors. My name is Dean Kalovis. I am the attorney for the appellee, Jeanna Coleman, who took off work and is seated in the front row of the seats back in the courthouse. Your honors, Mr. Coleman has given what I would categorize as an eloquent presentation for a pro se litigant. He's cited a lot of authority. He's maintained composure. And I know the courts are inclined, at times, while pro se litigants are under the same rules and regulations as regular counsel, I know that the courts sometimes they give a little leeway to pro se litigants because of the fact that that they're not trained in the area of law. Couple of things I want to note. One, this is the first time in this proceedings that Mr. Coleman has appeared pro se. And with all respect to Mr. Coleman, the arguments that he is asking this court to buy, I believe, are almost borderline offensive to the court, given the history of this case, whether he is a pro se litigant or not. First of all, I do stand by my original brief where I say emphatically that nothing that he's talking about right now was raised in the objections to the motion to show cause in this case. He's pretty much admitted this is the first time he's bringing all this up. So all these issues about the debt was paid, everything was satisfied, this provision should get thrown out. Okay, we didn't have a chance to address any of that at the trial court because it wasn't raised, and it's not properly before any of you for decision. And I think that that's without question. He literally admitted it himself. Plus, your honors, I know Mr. Coleman, he's kind of made reference in his brief that his lawyer was, for lack of a better term, an idiot. He's stated right now that he trusted his lawyer. His lawyer did some things without. He's asking somewhat for sympathies of the court. I want to note initially, and I feel bad I don't have the exact language, even if this court were to go back 11 years and allow him to get a delayed appeal to the initial divorce, I want to point out a few things. One, it was an agreement. He was represented by counsel and he signed everything. Two, this section 3.1 he's talking about, yeah, it talks about distributing his IRA, but it also says later, additionally, upon graduation or the youngest child turning 18, he owes her $15,000. It didn't specify it had to come out of his IRA, and even if it did, it doesn't matter, because as your honors have correctly noted, a lot of times if you keep a separate asset, that just means you've got the ability to pay it out of that asset. But it doesn't even mandate that it come from the IRA. It says he's got to pay $15,000. Now, Mr. Coleman is sitting here, oh, I was listening to my lawyers and I don't know what they were doing and I was just going by what they said. Your honors, the stipulations, which I brought with me, that are part of the record, that are signed by James R. Coleman, okay, stipulation, that pursuant to the, and this was in December of 2013, that pursuant to the original order of divorce in the within case, plaintiff James R. Coleman was to have paid defendant Jeanna Coleman $15,000 upon the graduation of his daughter Jessica from high school. Jessica graduated in June of 2010. Said obligation is set forth in section 3.1 of the party separation agreement and has not been paid to date. Now, the reason I'm sorry, Your Honor.
What is the document that you just read?
This, Your Honor, is a stipulation that is set forth. It is attached. It's attached to. I believe it was submitted to the court prior to the initial determination by the magistrate in this case of her ruling on the objections.
It's
Okay.
dated August 9, 2013.
It could be somewhere in that ballpark. You'll find it.
Is there a
was.
timestamp on what you?
If you let me check one thing, Your Honors, if you want to give me a minute. I know it's attached as an exhibit to the magistrate's decision, guaranteed, because we didn't have a hearing. And oh, by the way, as I said, the original trial, there was no hearing either. So as far as the court abusing its discretion to an abused order, that's a very, very difficult thing to prove. So what I'm trying to say, Your Honors, and also within these same stipulations, plaintiff filed a Chapter 7 bankruptcy in the Northern District of Ohio. Defendant was listed as an unsecured creditor. I want this court, and I say this with all respect to the court and with respect to the parties, to see this as what it is. He's supposed to pay her $15,000 when their youngest daughter graduated school, and he's going to go through whatever he can to get out of paying that debt. Okay? It wasn't raised in the objections. He knows he owes the money. In reality, in the real world, Mr. Coleman, when he filed bankruptcy within about a year or two after the parties modified their original agreement, thought that he was going to wipe this debt out. I don't know if that's what his lawyers told him or not, but he found out it is not wiped out, and bankruptcy doesn't wipe it out. So now he's going to do whatever it does to get out of paying this money, even if it means coming to this court and looking at you with a straight face and telling a bald-faced lie that he didn't think he owed this $15,000 when he knows darn well he did.
Counsel, let me just remind you that this is legal argument.
I understand that, Your Honor.
Okay, well, just bring it down.
I will.
Thank you.
The problem I have, Your Honor, is that while it is legal argument, this is a situation where there has been an enormous amount of time allocated to this file. There have been objections filed. There have been hearings in court. There has been an appeal brought to the Court of Appeals. My client has had to miss significant time off work. I've been sparsely compensated for an enormous amount of time put in this. And what I'm saying is, as an attorney who has been in practice now for approximately 28 years, I do have respect for the functions of courts. And I believe that the courts are here to hear legitimately presented and truthfully represented arguments and gripes. And what has happened, this has gone on now for so long. And every time there's some different explanation and reason why this debt isn't going to get paid. And it's come, once you sit there and you do the same thing over and over again, and the court system, which I have basically dedicated my career to, is abused by people coming to the courts and telling just straight-faced lies that I didn't know I was supposed to pay the money. I paid it already. Oh, my lawyers did this. Oh, my lawyers did that.
Well, you know, to Judge Moore's point, counsel, again, we have the facts, we'll have the entire record as well ahead of us. So the legalities of how it's brought before us, we will certainly have ample opportunity to review. So if you have additional legal arguments, we will certainly be able to, that will be what you're indicating, whether it be relevant to the determination of the question before us.
The legal arguments simply, Your Honor, are very, 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 very straightforward. One, Mr. Coleman is asking for a relitigation of the parties' agreed divorce decree 2004. All right, that is clearly beyond the scope of what this court can accomplish. Two, the items which Mr. Coleman is bringing forth to the court's attention were not properly raised via objection, and again are not properly before the court for determination. And three, the factual basis upon which Mr. Coleman is basing his argument is nowhere in the record for the court's consideration. Not only is it not in the record, but he signed stipulations acknowledging 180% opposite of what he's trying to tell this court he believes today. And I do apologize if I have become animated in my presentation on behalf of my clients, but this is something, Your Honor, when you have spent such a substantial amount of what I consider to be wasted, for lack of a better term, time, arguing something just to try to, for somebody to get out of paying something that they know they owe, it becomes very frustrating. And to me, it's even the court's time, I don't know that it's, I want to say it's almost a waste of time of all the parties involved, and even the court to some extent, because there are very legitimate and bona fide disputes that Your Honors have to make determinations over. And I just don't think this is something that is one of them. I don't really have anything else to say. I mean, my arguments are very succinct, and if any of you have any questions, I certainly would be willing to entertain them.
Thank you, counsel.
All right, thank you very much.
Mr. Coleman, you have just over 3 minutes remaining.
Thank you. First, just to reply to some of the council's comments, I do have also a copy of the stipulations that were signed by both parties. If I may, I want to read directly from the document. That pursuant to the original order of divorce in the within case, plaintiff J.R. Coleman, which is myself, was to have paid defendant Jeanna Coleman, the wife, $15,000 upon the graduation of daughter Jessica, et cetera, June 2010. I signed this for one reason only, because at the time these stipulations were sent, that the original order of divorce did state the $15,000 in there. That was pointed out to me, and I acknowledged that. I did not acknowledge that it was proper, but it was in the document. There was no arguing that. You can clearly see in my reply to the trial court that here's the conflict. This Article 3.1 should never have been in the original divorce decree. And so that's the issue of the stipulation. Counsel also raises the issue of extraordinary amount of time. And I apologize for getting a little passionate about this as well. I'm pro se. The counsel is the brother-in-law of the wife today. So I can see why he's also passionate about this. But relative to extraordinary amount of time, the day that this judgment decree was written, okay, was 2.5 years after the proceedings had started. What I feel also was an extraordinary amount of time for a divorce proceeding to go through. Countless delays and continuances on behalf of the wife. We had mediated an entire agreement, even prior to the filing for divorce, which she neglected and ignored, in fact. On this day, my counsel was advised by her counsel that she had planned to appeal whatever findings of the magistrate as a result of that trial. And I asked my counsel, what does that mean? That's another 30, 60 days or whatever that might be, or whenever. So I made a determination on that day that there was a single asset in the marriage, the home, that rather than trying to split up the home, sell the house, kick my daughters out of their home, I would agree to give her the home, give her the car that she drove, which was paid off, and whatever was left over, I got a garden tractor and some tools and whatnot. I did get a receivable from my mother, which I had loaned her money during the process, in part because the financial assets, specifically accounts, were being depleted by the wife, as was admitted in her own deposition, that's on record in the docket, okay? So I was under an extreme amount of duress, not only from time, but also from a financial perspective. I had brought to the trial that day an expert that was there to testify the value of the home, and that I could have taken half of the home in accordance with Ohio rules, but I chose not to do that because in my offer, it was to be done that day. And if you look at the date stamp of the document, it is the same date that the trial was scheduled. And so, I'm just trying to demonstrate to the court that there were other issues prior to this. Now, counsel did not represent the wife at the time. She was being counseled by a different party who later withdrew from the case, and then her brother-in-law was then introduced to the case.
And Mr. Coleman, I need to inform you that you've reached the end of your allotted time frame for today.
Yes, ma'am.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website.
Thank you.